Good morning, everyone. Welcome to Top 10 Ways to Stay Out of Court, sponsored by the City of Glendale. My name is Stephanie Neely. I'm the marketing director here at CEA. While everyone is getting settled in, I'd like to go over a few housekeeping details with you. Your audio will be muted throughout this presentation, but we ask for your participation through the chat box and the Q&A box at the bottom of your screen. If you have any questions about the content of the presentation, you can type them into the Q&A box at any time and we will address them out loud as we go. It's the icon with the two speech bubbles at the bottom of your Zoom screen. The handouts for this presentation were attached to the reminder email that included the link to this presentation. If you need them resent, please put your email in the chat box and we will resend them to you. If you experience any other technical difficulties, you can reach out to me in the chat box and I will help you troubleshoot. Because your feedback is very important to us, please complete the survey that will appear at the end of the presentation by accessing the QR code. It shouldn't take more than a minute to complete, and it provides us with valuable feedback that we use to constantly improve our webinars. This presentation will be recorded and available on the City of Glendale's website after the presentation. Your speaker today is HR Director Eli Nunez. Before we hand it over to Eli, we've got a word from the City of Glendale. Take it away, Ani.
Thank you, Stephanie. Good morning. My name is Ani Pagosian, and I'm with the City of Glendale's Economic Development team. The City of Glendale has partnered with the CEA to host a series of webinars to help answer your employer-employee questions. Thank you all for joining us today for our first webinar, Top 10 Ways to Stay Out of Court. It's my honor to introduce our guest speaker, Eli Nunez, who brings a wealth of knowledge and expertise to our event today. Eli is a strategic, pragmatic HR professional who has a vast amount of experience in manufacturing, agriculture, construction, distribution settings. With experience in both union and non-union environments, he gives employers the confidence to handle HR issues correctly so that they can focus on the rest of the business. Eli has a fun and informative training style and provides employers with resources so they can come away feeling like they can handle any issues that come their way. He has extensive experience conducting workplace investigations, Cal-OSHA investigations, and supervisor training. In his 20-plus year career, Eli has worked for Rite Aid, Target, Color Spot Nurseries, and more. We encourage you all to ask questions in our Q&A chat box. This session will be recorded for future reference as well. Take it away, Eli.
Thank you. Thank you very much for that great introduction. And thank you, everybody, for spending the next hour of your time with us. Before moving on to our presentation, I would like to remind everybody that the City of Glendale, again, has partnered with CEA to provide a complimentary hotline for employers in the city. So that number is 866-248-3074. You can give us a call Monday through Friday between 8 and 5, and we'll help you with any HR-related issues, whether it's hiring and firing, paid sick leave, leaves of absence, FMLA, breaks and lunches, handbook questions, harassment, anything like that. Give us a call. We're more than happy to help, and we look forward to hearing from you and look forward to expanding this partnership with the City of Glendale. A little bit more about us. As the introduction said, I am Eli Nunez, and I am with CEA, California Employers Association. And our goal is to provide our members and anybody that calls with peace of mind. We do that through exceptional human resources compliance solutions, training and recruiting services, phone support, that sort of thing. So basically, we try to focus on the HR side of things and staying up to date with it. So you can call us and then focus on your day-to-day business, keeping the business running, keep it growing, and leave the HR questions to us. Anything we can help you with, that's what we're there for. Having said that, though, I may have been a lot of things in the past life and worn a lot of hats, but one thing I am not is I am not a lawyer, and nobody at CEA is practicing law right now. So basically, any presentation, any advice we give is for educational knowledge purposes and not to be taken as legal advice. If you do have any questions of legal nature, we do ask that you consult with your own personal attorney, legal counsel, whatever it is, for a couple reasons. One, obviously, they will have your best interest in mind being your legal counsel. The other is for attorney-client privilege, which we cannot provide. So again, this presentation and any presentations going forward are for educational purposes, not to be taken as legal advice. And if you do have any questions of legal nature, please consult your attorney. Let's jump right into it. A few of the things that we will talk about today, of course, this is the top 10 ways that we've identified to stay out of court. So some of the overview of what we will be learning today. The first one is learning how to start and end the employment relationship in the best way possible. Hiring or especially terminations, that is the way that a lot of employers get in trouble. So we're going to teach you some of the do's and don'ts in both of those facets of the employment relationship to help keep you out of trouble. The other one's making sure policies and handbook are current and compliant. Of course, in the change in landscape that is California, our policies and our handbook have to be up to date. We have to make sure that they reflect what is allowed in the state. So keeping those up to date, being consistent with them, and knowing what they are, most importantly, can go a long ways in preventing you from having to face any legal complications. Of course, avoiding costly fines for any meal rest period violations or any employee misclassification claims. If you classify an employee as exempt when they should be non-exempt, you can be liable for any back wages, overtime, meal period violations, that sort of thing. So we're going to learn ways where you can avoid those fines. The other one is those meal and rest periods, of course. They seem very easy or very simple when we look at them, when we take a quick glance, but um, as experience has shown, year after year, there is a lot of fines and a lot of legal cases in the state of California based on those meal and rest period violations. So we'll talk about those a little. And finally, being proactive when you address any harassment issues, harassment claims, discrimination claims, anything like that in your workplace, whether it's, in the hiring process, termination process, or everything in between, we want to be proactive in addressing these issues. So we'll talk about the process for that, what we should do, what we should look out for, and how that can help keep you out of trouble in the future. So without further ado, let's jump right into it. Our top 10 ways to stay out of court. At number 10, we have strong hiring practices. Now at CEA, we'd like to say hire slow, right? And that's just half of what we like to say. We like to say hire slow, fire fast. We'll get to that part later. Hiring slow really means, taking your time at the beginning of the process, right? We'll get a little more in depth about it, but really, I mean, the thing to think about is when you hire somebody, that orientation, that first day, how they are immersed into the company is going to set the tone for their career with you. And in a lot of cases, it's going to dictate whether they're there for a long haul or if it's just a short stop in their career, right? So, when you bring someone on board, you should obviously go over the policies and procedures, the handbook. Make sure that you always have an at-will clause, whether it's in your handbook or a separate document, stating that employment in the state of California is at will, not for a contracted amount of time or anything like that, right? And we also want to make sure that anybody that's conducting interviews, hiring, that sort of thing, is not making any promises that would basically nullify or violate that at-will clause in the state of California. Of course, anytime you go over any policies, procedures, or anything with employees, you want to make sure that there is acknowledgements that are signed, stating that the policy was received, understood, and they agree to abide by it, to go along with any required new hire documents. And we're all familiar with them. If you've hired anybody, you got your I-9s, your W-4s, your wage theft note if it's non-exempt employees, your California tax forms. There's a myriad of them. So we want to make sure that you have your hiring process squared away, right? Have a good checklist that has all those documents in place, and make sure you're going through everything with your new hires. And thing to keep in mind, I mean, this is a tough recruiting market. It has been for the past several years, not just because of the pandemic, but because of other factors, the economy, people just choosing to do different things with their careers or what have you. So one thing we do recommend is flexibility can sometimes be seen as a part of the job rather than the perk. Maybe in past years, past decades, having that a flexible schedule or a flexible work environment was seen as something that could be offered, a perk on top. But really, I mean, with the work environment today, it's actually a part of a lot of jobs. So take a look at your specific position that you're hiring for to see if that flexibility is something you could build in to help make you more competitive in the hiring field. Now, a little bit more about hiring slow, right? And the thing is, take your time when you're looking to hire somebody, right? It's very, very easy, if you're an owner or a manager, to just listen to your supervisors, your foremen, people below you, and just say, hey, we need people, give me people, bring people in. Take your time, make sure you understand what the needs are, make sure they understand what the needs are, right? I mean, in many cases, you may not have to hire a full-time employee, a part-time will do, or you may not even need to hire anybody at all, right? If you're looking forward ahead, or more information than that person requesting the hire does, there's some shifts coming or anything, maybe you don't need to hire that person after all. So take your time, make sure that you understand what you need, make sure your team understands what you need, and that way you'll be sure that you're hiring the right person, right? So again, the employment relationship, like any other relationship, you want to make sure you do some research, take a look, get to know the person. That way, you don't just jump right into it. Okay. And when it comes to the interview process, right? I mean, there is some potential landmines that we want to avoid. Interview process, hiring process, whatever it is. And these are especially questions about any kind of protected class, whether it's age, family status, or what have you. And a lot of times, I mean, these can even come up accidentally, right? You're having a conversation with somebody, whether it's a candidate, a hire, someone that you're interviewing or what have you. And it comes up, hey, you went to a certain high school. What year did you graduate? Well, that question could be seen as trying to figure out somebody's age, right? Or if it comes up in conversation about somebody's family status, whether they're pregnant, whether they have kids or whatever, if you make the decision not to hire the person, it could be alleged later on that the reason for it was because of their family status, because they were pregnant, because of any kind of protected class. So you want to make sure that you're careful with those conversations, right? Next thing is salary history. We don't want to ask about salary history. In the past, that was something that we can ask even on job applications, right? Where did you work? How much were you paid, et cetera, et cetera. Well, that is no longer the case. The state does not allow us to ask about salary history. We can ask employees what kind of a range they're looking at, but we can't ask them exactly what they were paid. Of course, California is also a ban the box state, so we cannot ask about criminal history until after a conditional offer of employment is made. So you can make it a condition of employment, say in an offer letter, say, we're offering you this position based on successfully completing a drug screen or a criminal history background check or whatever it is, but you cannot ask about that ahead of time. So what we recommend is focus on questions about the job, you know, the duties of the job, how the employee is qualified for them, or what they will do to complete them. All right, next on our list is California's leave laws, right? We know California is chock full of protected leaves of absence, so more than 20 at last count. And I mean, it's important to be familiar with them because each law works differently, right? Some apply to your business, some don't. Most of the time, they are based on how many employees you have. And it's not just how many employees you have in your location or how many employees you have in California. It could be how many employees you have in your organization overall. So if you have one employee in California and 20 employees in, I don't know, Wyoming or something, your count is 21 for that case. So any laws that apply for businesses with 20 or more employees would apply to that California-based employee. So it could be very difficult, especially for small businesses, but it's very important to be aware of them. So know your employee count, know what laws apply to you, right? The other one is paid sick leave. And this is something we're pretty familiar with. State of California put this in place a few years ago. So just a little recap. I mean, statewide, all employees are eligible for 3 days or 24 hours of sick time. And that could be either on an accrual basis or a lump sum. You give it to them all at once, or they accrue it over time, based on hours worked, based on days worked, whatever it is. You can put some restrictions where they can't be used until 90 days. The important thing to think about sick time is, you're not required to pay it out at termination, right? So if employees terminated, you have to pay out their vacation, but not their sick time. Now, if you combine vacation and sick time into one single bucket, a PTO policy, then all the protections of sick time and all the protections of vacation apply. So you would have to pay that out. So that's why whenever somebody tells us they want to combine, vacation and sick into one bucket in the PTO, to be very careful because, a lot of times there are some responsibilities that come along with it, different things they have to do with it. So be very careful if you're looking to combine it. And of course, California being what it is, there are a lot of different municipalities, different localities with different paid sick leave laws, right? Bay Area comes to mind. There's some areas in Southern California as well, where there are additional requirements for sick time. Maybe it's a higher accrual cap, or other laws that apply to it. So it's important to be aware of what those are. Even if you're not located in that area, if you have remote employees or employees that work in those areas, then those laws could apply to them. So be aware, especially if you go into any bigger city or bigger urban area. Be aware, take a look to see if there's any specific paid sick leave laws that apply there. All right, next on our list, number 8, exempt versus non-exempt employees. Another way to be in trouble. So making sure exempt employees really are exempt is a great way to stay out of trouble, right? And again, this mistake can be costly for many reasons. One, if you misclassify an employee as exempt, you're paying them a salary, you're not paying them overtime, they're not taking their breaks, they're not taking their lunches, et cetera, et cetera. Then if it turns out that they should have been non-exempt, you may be liable for those back wages, back penalties, back overtime, along with some waiting time penalties and that sort of thing. So you can see on the screen a few of the recent cases there. 11 million agreement for overtime wages for long strugs because store managers and assistant store managers were misclassified. Taco Bell, $12 million in settlements for overtime violations in California and Washington. So these things stack up really, really quickly. So a little more about exempt versus non-exempt, of course. In order for an employee to be classified as exempt, there are certain conditions that they must meet, right? In the state of California, basically all employees, they're all classified, or they all go to non-exempt unless you can prove that they're exempt, right? That's the default. Everybody defaults to non-exempt. So in order for an employee to be classified as exempt, they have to pass both the duties test and the salary test. So as far as the duties test goes, I mean, there's specific areas that we'll discuss a little bit, some of the exempt categories. And for the salary, it has to be 2 times the state minimum wage. So you take the minimum hourly wage, which is $15.50 right now, multiply it by 2,080, which is a 40-hour work week for the year, and then you double that. That would be the minimum salary you have to pay to exempt employees in the state, right? And of course, I mean, the advantage possibly of having exempt employees is that overtime laws, meal and rest breaks, that sort of thing do not apply to them, right? So they're not having to clock in and out. You don't have to take their breaks. You have to pay overtime, that sort of thing. You're basically paying them a flat salary for the skills and knowledge that they bring to the job. So be very aware of that, right? And I mentioned, some of the exempt categories, of course, the white collar are the most common. And all of these have a duties test, right? So you have the executive or the managerial exemption, which is a very common one. That's the one where people that manage 2 or more full-time employees. Administrative, that's someone that works directly with management policies. So think like a HR generalist, for example, right? Not exactly a manager, but they work on policies, procedures, that sort of thing. And finally, the professional exemption, whether it's in the field of science or learning, someone that must be licensed or have an advanced degree. So lawyers, for example, right? They would qualify for that professional exemption. And the important thing to keep in mind too is that in order to qualify for these exemption, the majority of their work must be performed in these categories, right? So for example, if you have what's called like a working supervisor or a working manager, at least half of their time must be spent on those managerial duties, right? So if you have someone that works on the line, but you just call them a lead, but they're doing day-to-day work like everybody else on the line, that would not apply, right? They have to be doing the majority of their work in that category. And a recap, right? Your non-exempt employees, of course, your hourly employees, those are the ones that are paid by the hour. Got to have them clock in and out, or whether it's on the time card or some kind of an app or electronic clock or what have you. And of course, they are subject to meal and break and overtime laws. So now these could vary by industry, so make sure you're familiar with the wage order that applies to your specific organization or industry, and how that covers your employees, right? Because again, different things could apply based on different wage orders. You know, think of agriculture versus manufacturing, for example. There's different requirements or different laws for overtime or when overtime applies. So again, be familiar with your wage orders so you know what applies. Little slide here just reminding you of what the overtime is. Of course, you know, it went up to $15.50 at the beginning of this year. You know, we thought $15 was where it was going to settle for a while, but a few years ago when Governor was it Jerry Brown was in office, he signed the law, basically the one that increased the minimum wage, also had something in there that said, hey, if inflation is past a certain percentage for the year, guess what? It's automatically going to trigger an increase in minimum wage. So lo and behold, it happened last year, and here we are at $15.50, which of course also raised the exempt minimum wage for exempt employees. So if you have any employees that are exempt, they should be making at least $64,480 a year. Keep in mind, you know, if the hourly minimum wage increases, that exempt minimum wage is also going to increase. And of course, you know, just like there are different paid sick leave laws or requirements for different areas or different cities, we also have different minimum wages. As of last count, there was about 40 throughout the state of California, you know, and they usually increase at the beginning of the year, but then there is also mid-year increases. You know, we saw them throughout the state on July 1st, everywhere from Los Angeles all the way up to the Bay Area, right? There was a lot of increases, so make sure you're aware of them. And these could also apply to specific industries within the city too. The hotel industry comes to mind, right? Certain hotels with more than a number of employees have a different minimum wage than others. So again, be aware of those. You know, make sure that you are paying your employees correctly. And if your employee goes to do work in another area or lives in another area and works remotely, make sure that you are paying them correctly. Have a bit.ly link there for you that you can follow that takes you to a nice fact sheet, a nice spreadsheet that shows all the updated minimum wages throughout the state. All right. So moving on, but staying kind of the same theme, number 7 way to stay out of court. Follow the rules for your non-exempt employees, right? Your hourly employees. Now, keep in mind, any wage and hour claims can go back as far as 3 years in the state of California. So any violation that happened less than 3 years ago can still be can still land you in trouble, right? In some cases, you know, they've stretched that out even beyond the 3 years, but just 3 years, that's kind of the cutoff right now. So some of the things to keep in mind, of course, meal and rest periods, you know what the requirements are, know how many should be taken and what the time is. Overtime, wage statements, you know, there's certain requirements of what should be on there, right? What does the pay stub have to show? You know, hours worked, rate of pay period, et cetera, et cetera. We'll go over some of these requirements here in another slide. Also important to define the workday, right? And keep in mind, this isn't just the work shift. This isn't the shift that you work. This isn't 9 to 5. This is the workday when the workday starts. So for the most part, the workday starts at, you know, 12 a.m. on the day of and ends at 11:59. If you don't define it, that's what it's going to default to in the state of California. So it's pretty standard to keep it that way, but sometimes, you know, if you have different shifts that operate throughout the night, or if you run a 24-hour operation, you may look at shifting that workday one way or another, just so it makes it more consistent when you're figuring out overtime, scheduling, that sort of thing. So make sure that that is defined. The other thing you want to define as well is what is the work week. Again, you know, it defaults to Sunday through Saturday to mimic the regular calendar week. But again, you know, you may want to define it differently based on your business or your operating needs. It's very important to define that work week as well, because, you know, a lot of times we hear, hey, you know, if you work 7 days in a row, aren't you paid overtime or double time or what have you? Yes and no. Now, what the law says is that if you work 7 consecutive days in a work week, then special overtime rules apply for that 7th day. Again, that's in the work week, right? That's not 7 consecutive days. So that's why it is so important to define what your work week is. So for instance, if your work week is from Sunday through Saturday, and you have somebody work from one Monday all the way to the next Monday, it feels like they're working, you know, 7 days, but technically they're working 6 days in one work week. one day in the next. So those special overtime rules would not apply to that Monday because that is technically in another work week, not in the first one. A little confusing, I know, but once you look at it on the calendar or on a spreadsheet or something, it makes a little more sense. As far as rest breaks go, pretty standard. If you work less than 3.5 hours, no rest period is required. More than that, you require one rest period, and so on. Basically the rest periods required are based on how many hours are worked that day, right? And you want to schedule it as close as possible to the middle of a work period. So there's no law that says that you have to take a break by your second hour, or at your second hour. It just says as close to the middle of a work period as practicable, right? So we want to make sure that we're scheduling accordingly. And most importantly, too, we also want to make sure that we are relieving employees of all duties during that break. We're basically relinquishing all control, right? So if it's a 10-minute rest break, we can't say, hey, go take your 10-minute break, but don't leave the lunchroom, or don't leave the store, don't leave the work area. At that point, you're not fully relinquishing control. Employees are free to do whatever they choose to during that 10 minutes. If they want to go sleep in their car for 10 minutes, they can do that. If they want to go off the premises, run over to the corner convenience store and grab a slice of pizza or whatever, they can do that, right? We can't, enforce any controls or rules over them during their break. And of course, as employers, a lot of times we get the question, hey, my employees aren't taking their breaks. What we always ask is, well, are you letting them? Are you authorizing them to take their breaks? Yes. Are you giving them the ability to? Yes. At that point, an employer's responsibility is just to authorize and permit employees to take the break, give them the ability to. If they choose not to, we're not the break police. It's not on us to make sure that they're taking it. It's just up to us to make sure we're giving them the ability, the opportunity to take that break. Meal breaks, of course, very similar to it as well. Work less than 5 hours, there is no meal break required. More than 5 up to 10, 1 meal break, and over 10 hours, you have that second meal break, right? That is required. Now they can waive that second meal break if they work less than 12 hours, by mutual consent. So that means they waive it, you waive it, get some kind of documentation, whether it's a one-time paper that they sign saying they want to waive it, or if it's, every time it occurs, whatever it is. The other thing is make sure that if there is specific requirements for donning or doffing equipment, if they have to put on a lot of safety equipment, taken off, et cetera, make sure that that is done on the clock, not off the clock. Okay. And fairly recent court case also basically ruled that rounding meal breaks should be avoided, or is better said, it's not allowed. Because you can't be sure if you're rounding that they are taking the full required 30-minute meal break, right? So say for instance, someone clocks out at 12 o'clock with 59 seconds, and they clock back in at 12:30. That's not exactly 30 minutes, right? That's 29 minutes and 1 second. So we want to make sure that we are not rounding. If you have the ability to keep time exactly, make sure that that is what you're doing for your meal breaks as well. We recommend you do that for the start and ending time as well, just to avoid any claims of rounding or whatever. But the state does allow rounding for punching in, punching out for the start and end of your shift, just not for meal breaks. So make sure that we're not rounding those meal breaks. And finally, for overtime requirements, pretty standard. It's time and a half. Again, review your wage order because they could differ in your industry, but it's time and a half for any hours worked over 8 in a workday, or for any hours worked over 40 in a work week, right? It's not either or. I'm sorry, I should say it's if you work more than 8 hours in a day, you get overtime. If you work more than 40 hours in a week, it's overtime as well. And again, here's that 7th consecutive day in the work week we talked about. The first 8 hours are paid at time and a half. Anything beyond that is paid at double time. Double time is also paid on a regular day for any hours worked over 12. And very important to keep in mind, your overtime pay is based on the regular rate of pay and not the hourly rate of pay. So questions on that basically is if you give any non-discretionary bonuses, if you have a shift differential, that sort of thing, those should all be factored into the rate of pay to figure out what the overtime pay should be for that employee. We also received this graphic you can take a look at with your handout as well. This lets you know what should be on a wage statement, right? What is required to be on a wage statement in order for it to be compliant with the state of California. You know, some of the basics, of course, name and address of the legal entity or the employer, right? You want to make sure that's on there. Some kind of identification number for your employee, whether it's the last 4 digits of their social or an employee number, whatever it is, make sure that's on there as well. Make sure listing the pay period and all the rates that apply. And very importantly, paid sick leave, you know, that should also, we recommend that's on your wage statement. You can have that on a separate statement that's made available to employees at the same time as their wage statement as well. So if you don't have the ability to add that to the wage statement, make sure you're printing up a report for them and giving it to them when you give them that wage statement as well. All right, let's keep on moving here to number 6. Independent contractors can also get you in trouble. So avoid misclassification of independent contractors. That is a good way to avoid being, being in litigation because of it, right? So California has what is called the ABC test when it comes to independent contractors. And a lot of times we want to say that we're going to hire somebody to come in and help us out. They're going to be an independent contractor. We're going to pay them for the job. Well, in order for somebody to truly be an independent contractor, one, they have to be free from the control and direction of the hirer. In other words, if you're hiring somebody on to come in and paint your building, you're not going to tell them exactly, how to do it, give them the day-to-day, basically manage the whole process, right? You're basically paying them to perform a specific project or a specific job. The other one is they have to perform work that's outside the usual course of the hiring entity's business. So for example, if you're an accounting firm and you need help, so you hire an accountant to do the same thing that everybody else is doing, guess what? They're not independent contractors because what they are doing is in the usual course of your business. It's got to be something beyond. So staying with the accounting firm example, if you're an accounting firm and you hire somebody in to come in and do IT work for you, you have to get a new server or whatever, that is outside usual course of business. So that may qualify as an independent contractor. And the third one, the independent contractor must be engaged in the trade, occupation, or business that's the same nature as the work performed. So if you hire a plumber, they're going to come in and do plumbing work, right? You can't hire somebody, again, you know, and just say, well, their title says they're doing this, but they're doing the same job as everybody else. No, they have to do the same work that's related to the trade or what they do on a day-to-day basis. So what we always recommend too is if you have any questions, if you're hiring somebody, whether it's independent contractor or not, and we could walk through this ABC with you, but of course we always recommend, if you're not sure, consult legal counsel just to see what your exposure is there or to see if the person truly is or qualifies as an independent contractor. All right, number 5, prevent and promptly correct harassment. As we know, I mean, harassment in the workplace is something that's taken seriously in the state of California, right? We do have that mandatory harassment prevention training. It started just for managers and supervisors. Now it's spread. There's mandatory training for all employees in most businesses. So, of course, the best way to avoid this to avoid any kind of harassment or any kind of harassment claim is make sure that you're promoting that professionalism, have that respectful workplace, right? And a lot of things, one of the questions we get is, well, what if it happens outside of work? What if it happens in the parking lot, or what if it happens way outside of work at happy hour on the weekend or what have you? I mean, keep in mind, it could still be, it could still come back to haunt you, right? If you have 2 co-workers that go out for happy hour and something happens, guess what? That's going to affect the employment relationship, right? So there could still be a harassment claim that arises out of it. Or you have somebody that's interested in the coworker and keeps asking them out. They asked them out at work, they said no. Outside of work, they sent them 50 texts following up or asking them, hey, that still applies. So harassment can occur anytime, anywhere. So make sure you have an open door policy. Make sure you're encouraging communication in the workplace so that people are comfortable or they have a channel to report these issues whenever they are occurring. More of the training requirements, as mentioned, most businesses in California. So any business with 5 or more employees must provide harassment prevention training every 2 years, right? So that's a 1-hour training for your all employees, and or a 2-hour training if the employees are in a supervisory or management position, right? Anybody that's hired or onboarded, you have to give them that training within 6 months. And if they're seasonal employees or temporary employees, and you know for a fact you're hiring them on as seasonal or temporary, you should give them that training within 30 calendar days if they're going to be with you for 6 months or less. So if you hire a lot of seasonals or temp employees for your business, make sure that you're making that harassment prevention training either part of the onboarding process or part of that first 30-day plan for them. Now we do have this great graphic here that I always recommend for anybody that's in a management position, supervisor position, or what have you, to become familiar with. These are our investigation triggers, right? So how do we know if we need to look into a harassment or discrimination claim, right? And the first one, I mean, the first thing to keep in mind is when an employer knew or should have known that something was going on. Well, how can we say, well, the employer should have known it was going on? Well, guess what? Your supervisors, your managers, your foremen, your leads, they are all technically seen as agents of your organization. So if your lead knows that there's harassment going on or witnesses it and says or does nothing about it, you can't just say, oh, well, only the lead knew. I didn't know. I'm the owner. It never got up to me. Doesn't matter. As far as the state is concerned, if one of your agents, one of your managers, supervisors, leads, whatever, knew about it, the organization as a whole knew about it. So again, make sure that you're training leads, supervisors, managers to identify harassment or at least to escalate if they have any questions about it. Some other things, any suspicion, if you suspect there's any conduct, not sure if something's harassment, but it doesn't sit quite right with you, look into it anyways. Ask a few questions, take a look, talk to people just to see if there's anything going on. If you observe conduct, if you see it happening, you have to investigate, you have to act. Any complaints, whether they're formal, informal, anonymous complaints, those should also trigger an investigation. Administrative, this is when you get that notice in the mail asking for copies of an employee's pay stubs or copies of an employee's file or anything. And that should trigger you to look into things because obviously, if you get that notice, it could be bad news. Any unexplained changes in the workplace. So for instance, you have a group of employees that always used to sit together, always used to work together. Suddenly you notice one person's isolated themselves from them or the dynamics changed. I know, we have a lot to worry about at work, keeping the business running and everything, but if you notice these changes in your workforce or in those behaviors, it should be a trigger for us to look into it, right? We should investigate to see what is going on, see if there's anything beyond just a slight disagreement, maybe. And finally, rumors and gossip, do rumors and gossip exist in the workplace? Absolutely. If they make their way up to us, should we look into it? Absolutely as well, right? Because if you're hearing all these rumors, gossip, that sort of thing going around, one, it could mean that there's something going on out there you should look into, or two, it could mean that someone's being targeted out there with these rumors and gossip, and you need to look into it to make sure it's not harassment or that it's not escalating to that point. So any of these things happen, it should, trigger an investigation for you. And by investigation, I don't mean, a full blown bring in outside parties, interview everybody in the workplace sort of thing. It just means it's something you need to look into. You need to do your due diligence to make sure harassment or discrimination is not happening in the workplace. All right, number 4, way to stay out of court. Follow and keep your employee handbook updated. I touched on this a little bit at the beginning, right? I mean, your employee handbook, we like to refer to it as your sword and shield. It's going to defend you. It's your first line of defense, right? When it comes to any claims, when it comes to any discrimination, when it comes to any policy violations, that sort of thing. So some of the things you want to make sure that are in your handbook, what's required, of course, harassment prevention statement, right? You're going to know, the protected class says you're going to state that harassment is not tolerated, it's against the law, et cetera, et cetera. Lactation accommodation policy, make sure that is in your handbook. If you have it separately, make sure you give that to all your employees. Don't just give it to the women. Don't just give it to the women that are, in childbearing age or whatever. Give it to everybody, please. Mandated or protected leaves of absence. Make sure that those are in your handbook as well. talking about FMLA if you're a large enough employer, otherwise CFRA, pregnancy disability leave, paid sick leave, and make sure that you have an at-will statement in there, confirmation that employment is at will, can only be modified by, a specific person, whether it's a CEO, the owner, or what have you. Make sure that that is in your handbook. Something else, we recommend, you could also have something in there about meal and rest breaks, overtime, vacation, holidays, any other leaves of absence, that sort of thing. The handbook really is a good reference for your employees, right? But at the same time, it also helps us set those expectations for them. So whether it's behavioral, whether it's any other kind of policy you want to put in there, conflict of interest, whatever it is, you are helping to set those expectations for employment or for your employees in the handbook, right? The other thing is about the handbook is make sure once you have those policies out there, they're understood, that you are applying them consistently across the board. Because otherwise, if there's no consistency, guess what? You're opening yourself up to claims of favoritism, discrimination, harassment, etc., whatever it is. So consistency is going to be your friend at in this case, right? And finally, when you're giving out that handbook, usually that's one of the first things we give out to our new employees. So make sure you're setting that positive tone for your business, right? You want to make sure employees know that you're protecting them, whether it's from harassment or any other undesired behavior. You want to make sure you're introducing the company, showing the good light, showing how you want to run that company, right? Showing what the expectations are for employees, for the company, for yourself. So make sure you're setting that positive tone in the handbook. Okay. Some best practices as well. Make sure you're reviewing that handbook on a regular basis. Do laws change in California? Absolutely. Every year, sometimes more often than that, sometimes every couple months. So make sure that you're reviewing that handbook at least once a year so it is up to date. Distribute it to your employees, right? Whether it's new hires or if you make any changes, make sure you're distributing the new handbook or at least those changes to everybody out there, and you get acknowledgements back saying that they were received, right? Again, follow your handbook, make sure you're consistent, make sure that it is effective. We've had cases before where people call us up, they ask us a question, hey, this happened, what should we do? Our response is, well, what are your policies? What does your handbook say? Oh, well, our handbook says this, but we don't really follow it because we never really do that. Why is it in your handbook then? Because guess what? If you try to do anything, if you try to do any corrective action and it goes contrary to what's in your handbook, your employee's gonna bring your handbook and say, nope, you know what? That's not in the handbook. This is what I was basing my actions on. This is what my expectations were. So make sure you're following your handbook. If there's any changes again, update it. And finally, train your managers. Your managers, your supervisors, those people that interact with your employees day to day, they are your first line of defense. And they could also be the ones that are going to get you in trouble if they're not being consistent, not following policy, not treating everybody fairly. So make sure you train your managers, make sure you emphasize the importance of that consistency, of the fairness of following those processes. Of course, reminders, make sure you have your other updates, your federal law and labor posters, injury and illness prevention program, COVID-19 plan. I know COVID's in the rearview mirror for the most part, but we're still required to have that COVID prevention plan, whether it's part of your injury and illness prevention program or separate. Just make sure you keep it up to date. Those things keep changing. They just changed again in May. So make sure that those are up to date, filed, and that you're treating them as living documents, right? Anytime there's a change, whether somebody leaves or there's a change in the law, you're updating that in those policies. All right, on the home stretch here, number 3, insurance and your business. How can insurance keep you out of court? Well, workers' compensation is the first thing that comes to mind when we talk about insurance in the workplace, right? So what we recommend is know your carrier, Don't just sign up for a policy and throw it in your desk somewhere and forget about it until you need it. Reach out to them, They usually have resources, whether it's training, whether it's, online resources, whether it's, educational material, whatever it is, make sure you're accessing all of that, right? Develop a relationship with them, know your adjusters, know your carrier, know what the process is, more importantly, and train the appropriate people for it, right? if you're not going to be the one that's always reporting those workers' compensation injuries, if you have somebody else that does it, make sure that they are trained on it. Make sure that your leads know what the proper process is when somebody is injured on the job and what the follow through is with that, right? If there's restrictions, if there's any kind of modifications, how do you route those? So make sure you know that process all the way, and make sure you work closely with your workers' compensation carrier to see what that process should be. And the other one, of course, is also different insurance you could get for employment practices, whether it's protections against claims by employees, former employees, or potential employees, discrimination, harassment, any sort of thing. There are insurance policies you can get for that. So make sure that if it's something you want to pursue, contact your agents. We also have resources that we can refer you to for that, but make sure you are familiar with them, what the protections are, how far they extend, and what they can offer you aside from just a policy, a certificate, a piece of paper, because I assure you, most insurers are going to give you some other resources to prevent any kind of serious occurrence from happening, right? Because if something serious happens, they may be on the hook. They may have to pay out. So if they can prevent it, if they can provide education or any kind of resource to prevent these things from happening, they would happily do so. So just make sure you're making the most of it. All right, number 2, using effective discipline and documentation. If there's one thing I would tell a new supervisor, manager, lead, whatever it is, somebody that's in a position where they manage other people, it would be document, 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 right? Documentation is going to be your friend no matter what you do down the road. So of course, I always recommend, hey, if you can coach someone, if you see someone that may be going down the wrong path, address it early, coaching, give them a little nudge to get back in the right direction, right? When you do so, we want to be direct, want to state the problem and talk about what the consequences are. We're going to address that directly with the person. That doesn't mean, call them out, yell at them, berate them, or whatever. It means we're going to have an educated conversation with them, state the problem, state possible consequences, and ways that they can correct this behavior, right? Because at the end of the day, that is what we want to accomplish through corrective action and coaching, isn't it? We want to correct that behavior. If your only goal with corrective action is to get rid of somebody, at that point, I mean, it's too late. We've missed a lot of opportunities to correct that behavior before then, right? So make sure that we are addressing it. And of course, if you do have to issue any kind of corrective action or documentation, present a copy to the employee, ask for their signature. So what happens if they don't sign it? Does that mean it doesn't count? No. No, all their signature does is acknowledging that they received a copy of it, right? If you're given employment corrective action that's documented and they refuse to sign it, make a note of it. Hopefully you have somebody there as a witness that says, hey, employer refused to sign, file it away, and you're good to go. The important thing is to have some kind of proof or documentation that you presented to them, give them the opportunity to correct that behavior. Okay. Some suggested guidelines as far as discipline goes, present discipline as the guideline rather than required progressive steps. So what this means is we don't want to lock ourselves into, say, for example, a 3 strikes and you're out policy, right? Especially if you're very vague about it. If you say something like, three occurrences of undesired behavior could lead to termination. Well, what's undesired behavior? And how do you weigh it differently, right? Is a fist fight going to be weighed the same as leaving a mess in the microwave? If you're too vague, that's how it could be seen, right? So what we recommend is, yes, progressive discipline is good. Yes, we want to use it as a tool, but don't lock yourself into it. Don't guarantee that you're going to give those 3 chances or 5 chances or whatever it is, So you can have some language that says, like our example here says, violation of any company policy, either written or otherwise, may result in disciplinary action up to and including termination. At that point, it is up to you to determine what the appropriate step is based on the severity of the situation and based on the history of the situation. Has it happened, 1 time before? Has it happened 100 times before? You can make a decision based on that and then build consistency from there, right? However you address that situation, you're going to use that kind of as a measuring stick for other situations that arise in the future. And of course, we always want to make any decisions, whether it's corrective action or any other work related decisions, based on work factors only. So don't write somebody up because they're too old, or write somebody up because, whatever it is. Just make sure it's based on things like work performance, attendance issues, safety violations of company policy, right? These are all things that are quantifiable, things that are controllable, things that are not based on their protected class, right? You're not writing somebody up because they're of a specific gender or a specific race or because they're pregnant or whatever it is, Make sure that we're making decisions based on work factors. Same thing, if you're going to promote somebody, you're not going to, deny somebody a promotion because they're pregnant, they're going to miss time. No, 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 no. We're going to base it just on work related factors. So of course, we have some protected classes in California you want to be aware of when you're making decisions, just to make sure you're not making it based on these, or that it could be perceived that you are. And as you can tell, there is quite a few in the state of California, including the newest one for this year, reproductive decision making. That is a protected class in California now, which means you cannot discriminate or harass somebody based on decisions on reproductive health, whether they're pro-choice or pro-life, whether they're, take birth control or not, whatever it is. We cannot base employment decisions or discriminate against somebody based on that decision making. So what can we do to prevent this? Of course, focus on work, right? We come to work. So make sure that employees know we're focusing on work during work hours. Make sure that make sure that we promote civility in the workplace, no matter what we're talking about. I mean, we've seen political discussions can get very passionate, other, religious discussions can get very passionate. So make sure that we're promoting civility, stepping in when we need to make sure that dialogue stays that way. Enforce our harassment prevention policies and other policies equally, and make sure we don't allow politics to be used as a cover for harassment or discrimination, whether it's national origin, gender, race protections, whatever it is, certain slogans, certain words, certain catchphrases or whatever, if they are targeted against a specific group, a specific gender, a specific ethnicity, guess what? It doesn't matter that it's not the well-known harassment words that we all know. If it's targeted based on one of those classifications, it could be illegal, could get you in trouble. Use of technology, make sure we're enforcing those policies as well, and allowing, allow space for creative discussion, right? I mean, it's okay to have different opinions, different, different ideas, different everything, but make sure that employees know we're going to express that respectfully. Now, as far as discipline goes, of course, make sure that we are enforcing disciplinary policies for any violations of our employee policies, right? Even if it's not your big ones like harassment or discrimination, there's still other policies that we can have in place as employers. So make sure that we are enforcing those. We're enforcing those consistently as well. Okay. And make sure again that, your policies, just that consistency, right? Applying those policies consistently across the board, whether it's different, whatever the differences are, make sure that we're being consistent regardless of other factors. That is going to help us down the line. All right. And our number one way to stay out of court, and this is the second half of our initial saying, we said hire slow, fire fast, and with no surprises, right? So when it comes time to separate, to let somebody go, to terminate somebody, it should not be a surprise, because by then, you should have gone through corrective action more than likely. There should have been some counseling, some coaching, some conversations about it, whatever it is. It should not be a surprise. I mean, sometimes you could say, well, we can't, well, what if we have to shut down the business? Okay, well, if it's unknown to everybody, it's unknown to everybody. But when it comes to a performance-based or a policy violation-based termination, it should not be a surprise. You've either counseled them about it before. They should know what the policy is. You should have presented to them, whether it was in your handbook, your orientation, or when the policy was introduced, whatever. Make sure that there is no surprise for it. Of course, there's always forms required, just like there's certain required forms for hiring. There are some for termination as well. We have to give them the unemployment information form there, as well as other forms related to insurance, notice of change in employer relationship, that sort of thing. So make sure that we are providing those forms to all our employees at termination. You will be provided this slide. There's a good way of building another checklist, right? Checklists are very helpful when it comes to hiring or terminating employees to make sure that you're meeting all the requirements, which includes payment of wages. So if you're involuntarily terminating somebody, if you're going to fire somebody, the minute those words leave your mouth, you should be able to provide them with their final pay up to that exact moment, right? So if you're gonna let somebody go, you should have that check ready or whatever it is, that final check. Make sure that you're ready to provide it to them upon termination. If someone quits voluntarily, they give you more than 72 hours notice. If they say, hey, it's Monday, my last day's on Friday, guess what? Friday at the end of the day, you have to have that check ready for them at the end of their shift. If they give you less than 72 hours notice, you have 72 hours after that notice is given to provide them final pay. And that's 72 calendar hours, right? Not 72 business hours. So if they quit on the Friday, you got to give them that check on Monday, right? That's 72 hours after that. Only mail that final payment out if the employee requests it in writing and provides you the mailing address. Because if they don't, guess what? If they don't ask for you to mail it to them and you mail it and the check gets lost in the mail, the dog eats it, or, the neighbor snatches it or what have you, you could be liable for waiting time penalty. So make sure that, you're only mailing it or direct depositing it with permission. So now when it comes to terminations, some best practices, make sure that we have a witness present for it to happen. If you can avoid doing it one-on-one, please do so. If an employee is resigning and they tell you, hey, Friday's my last day, get it in writing, please. I mean, you'd hate for the person to start, changing the date or flip-flopping around or whatever. So if you have an employee that resigns, make sure that we get that in writing. Exit interviews are your friend. I mean, sometimes you know what they're going to say, especially if the employee is very disgruntled before termination or before they leave or what have you, but you could still get some valuable information from there. And of course, termination checklist. Make sure that we have one in place so that we're not missing anything. So to recap here, want to make sure that you're reviewing internal procedures for compliance, handbooks, policies, training, onboarding, termination, whatever it is. Make sure that we are reviewing all these procedures. Have your checklist ready. Make sure that we're compliant with everything. Make sure you're training your supervisors and managers so that policies are followed. Again, they're your first line of defense. Have that open door policy, give people different channels to where they can voice their concerns or identify any issues going on out there so you can address them. Review policies with employees to make sure they're clear. Don't just give them the handbook. Make sure you're discussing it, explaining it, make sure that they're clear on those expectations and policies. And finally, update that employee handbook at least once a year. So that brings it to the end. I will open it up to any questions in the Q&A box if anybody has it. If you don't have any questions for the Q&A box right now, you can always call that 800 number I gave at the beginning with any questions on this presentation, this topic, or any other HR topic. While we wait, I will say we do have some membership plans. If you're interested in membership beyond the hotline, anything from associate to ultimate, including monthly plans. And for those of you that are here for continuing education, I do have some codes for you. HRCI code is 631642, and the SHRM code is 23-KF4SK. Do not forget that dash or SHRM will be upset. So with that, I will give it back up to you to take it home while I put up a slide for feedback survey from you. So
Thank you, Eli. So much for this informative session. Thank you all for joining us as well. Please do save the date for our second webinar on August 23rd at 10 a.m. and that will be on labor law updates. This session is also recorded and it will be live on our website. I will also include the link as well. And if you do not have any questions, like Eli said, you can always contact that 1-800-HR hotline number, which we can include once again. Stephanie, do you want to include that in the chat box?
Yes, I can. Just give me one moment.
Okay. That's the website.
By publication.
I can include it. 1 moment. 248.
yeah.
3074. Okay. We'll wait another minute if there are any other questions.
Yeah, so give us a call with any questions. Again, we'd appreciate your feedback. Let us know what you thought about the presentation, or if there's some other topics you'd like to hear about. There you go.
Awesome. Thank you so much, Eli, and thank you, Stephanie. And thank you all for joining us today.
Yes, thank you everybody for joining us today. We hope to hear from you soon on the HR hotline. Go out and have a wonderful rest of your afternoon.
Bye-bye.